Today, we will have some basic knowledge about what is CPC, that is Civil Procedure Code, and why was it enacted. So, without wasting any time, let's begin with the question and answer round. And let's start gaining some basic knowledge about the Civil Procedure Code. So now, let's start with the first question, which is the inherent power of the court can be exercised under the code for what reasons? The options are A. To help the plaintiff, B. To help the defendant, C. For the ends of justice or to prevent the abuse of the process of court, or D. To grant interim relief. The correct answer to this question is option C, that is, for the ends of justice or to prevent abuse of the process of the court. The inherent powers of the court are exercised. Moving on to the next question. A residing in Dehradun beats B in Delhi. B may sue A under the code at which of the following places? The options are A. Delhi, B. Dehradun, C. Either A or B, or D. Only A and not B. The correct answer to this question is option C, that is either A or B. That means that B may sue A either at Delhi or at Dehradun. The next question is a person may sue a foreign state by doing what? The options are A. By only with the consent of central government, B. With the consent of the President of India, C. With the consent of the state government, or option D, that is both A and C above. The correct answer to this question is option A. That means to say a person may sue a foreign state only with the consent of the central government. Now, let's move on to the next question, which is the objection as to the place of suing shall be allowed in the court of first instance is the essence of which of the following sections? The options are A. Section 22, B. Section 21A, C. Section 21, or D. Section 20. The correct answer to this question is option C, that is, according to Section 21, the objection as to the place of suing shall be allowed in court of the first instance. So now let's see what does Section 21 states and means. So after that, let's move on to another question, which is where it appears to the court that there exists the element of a settlement, the court shall do what? The options are A. Leave the matter undecided, B. Decide the matter itself, C. Refer the same for arbitration, conciliation, or mediation, or D. None of the above. The correct answer to this question is option C, that is, where the court sees that there exists the element of settlement outside the court, it may refer the matter for arbitration, conciliation, or mediation. The next question is a decree for execution cannot be sent to which of the following courts? The options are A. Foreign court, B. Court outside India established by the authority of the central government, C. Both A and B above, or D. Neither A nor B. The correct answer to this question is option E, that is foreign court. That means to say a decree for execution cannot be sent to a foreign court. It can only be sent to the courts that are situated in the geographical area of the country. Moving on to the next question, which is which of the following must be stated in the pleadings? The options are A. Facta Probanda, B. Facta Probentia, C. Both A and B above, or D. Neither A nor B. The correct answer to this question is option A. That means to say a pleading can and shall only contain facta probanda. That means to say the facts containing the information about the matter. Let's now move to the next question, which is agreement between the parties to institute the suit relating to the dispute in a particular court happens how? The options are A. It does not oust the jurisdiction of the other courts. B. May operate as estoppels between the parties. C. Both A and B above, or D. None of the above. The correct answer to this question is option C. That is, both A and B above are correct. That means to say the agreement between the parties to institute a suit relating to a dispute in particular court does not oust the jurisdiction of the other courts and may operate as a estoppel between the parties. So now let's move on to the next question, which is the doctrine of res judicata applies to which of the following circumstances? The options are A. Changing circumstances, B. Static situations, C. Both A and B above, or D. None of the above. The correct answer to this question is option B. That is, res judicata applies to static situations. So now let's take a look. What is res judicata and what does it imply? After knowing about the res judicata, let's now move to the next question, which is a judgment delivered by a foreign court of competent jurisdiction can be enforced by Indian court and will operate as res judicata between the parties thereto, except in the cases mentioned in which of the following sections? The options are A. Section 14, B. Section 13, C. Section 12, or D. Section 11. The correct answer to this question is option B. That is, Section 13 mention the cases that are exceptions to the rule that the judgment delivered by the foreign court of the competent jurisdiction can be enforced by the Indian court and will operate as res judicata between the parties. So now let's take a look. What is Section 13 and what does it state? So now let's move on to the next question, which is which explanation of Section 11 states that where a representative suit has been decided, such a decision would operate as res judicata. The options are A. Explanation 6, B. Explanation 5, C. Explanation 4, or D. Explanation 2. The correct answer to this question is option A. That is, Explanation 6 of Section 11 states that where a representative suit has been decided, such a decision will operate as res judicata. Let's now move on to the next question, which is an order allowing or disallowing an application for the amendment is dash. The options are A. Appealable, B. A decree, C. An appealable order, D. None of the above. The correct answer to this question is option B. That is, none of the above is correct. That means to say, an order allowing or disallowing an application for amendment is neither an appealable order, a decree, or an appealable order. Moving on to the next question, which is the defendant against whom an ex parte decree has been passed can refer an appeal under which of the following provisions? The options are A. Order 9 Rule 13, B. Order 47 Rule 1, C. Section 96 Clause 2, or D. None of the above. The correct answer to this question is option C, that is, Under section 96 clause 2, the defendant against whom an ex parte decree has been passed can prefer an appeal. So now let's see what does section 96 states. Section 96 states appeal from the original decree. This section states that clause 1, save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising the original jurisdiction to the court authorized to hear appeals from the decision of such court. Clause 2 states that an appeal may lie from the original decree passed ex parte. Clause 3, no appeal shall lie from a decree passed by the court with the consent of the parties. And clause 4, no appeal shall lie except on the question of law from the decree in any suit of the nature cognizable by the court of small causes, when the amount or the value of the subject matter of the original suit does not exceed 10,000 rupees. After gaining that knowledge, let's move on to the next question, which is where the relief claimed by the plaintiff is undervalued and the valuation is not corrected within a time fixed or extended by the court, then what happens? The options are A, the plaint may be rejected, B, the plaint will be rejected, C, the plaint will be returned, or D, either A or option C will happen. The correct answer to this question is option B, that is, where the relief claimed by a plaintiff is undervalued and the valuation is not corrected within the time fixed or extended by the court, then the plaint will be rejected and will be termed as an incorrect plaint with, and the court may, if it deems fit, may order to file another plaint or a fresh plaint. Now let's move on to the last question for the day, which is which of the following does not deal with the final determination of the contested questions and have the binding effect in future litigation? The options are A, res sub judice, B, res judicata, C, stare decisis, or D, both A and B. Correct answer to this question is option A, that is, res sub judice is the principle which does not deal with the final determination of the contested questions and have the binding effect in future litigation. That's all for today. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.